Next is, I spent a lot of time grading exams last week, and there are some general exam mistakes to discuss. This would be more useful, and this is why it's very useful to you to have someone look at your exams directly. But these are general things that you can look out for on your exams or on your practice exams as you go over something. You can see if you're falling into one of these mistakes or not, these very high-level general categories of mistakes. And some of these are three little bears Goldilocks. So you want to be sure that you're not falling into certain holes, and you want to make sure that you're not falling into one extreme or the other as to certain kinds of mistakes that you would make. Some of these are just general issues that may not necessarily have a different effect that you're trying to counterbalance. So in places I've seen people write too many facts. In others, I've seen people write too much law. This is one that's not counterbalanced and that everyone could do more of. In many places, there's too little law fact glue. That's a weird thing to call it, but I'll explain what I mean in a bit. Many people are engaging in insufficient nitpickiness as to facts that are set out before you. And this is a general editing thing. Some of you are writing too long or saying perfunctory things, where I think you could get to the point or skip phrases that aren't necessary. So let's go through each of these briefly. On too many facts, I've seen facts followed by facts followed by facts. Sometimes some people will write two, or basically recite 2 or 3 facts from the hypo without going into deeper analysis of just reciting them and without referring to the law. You can go back over your own exam and ask yourself, if you see 2 or 3 facts that are piled up with no further analysis, which is your own interpretation of what those facts mean, what their importance is, without a reference to the law, ask yourself why you're doing that. Exams are tightly packed with facts, and this will get to the nitpickiness point in a bit, but nearly every fact has some kind of legal significance, or you should at least treat each fact like that's the case. So it's weird to begin to pile up 2 or 3 facts without discussing that. Now, it's easy for me to say this is a problem. One thing that you may, and I realize a lot of you, these are very hard things to do, doing practice exams. So there are mechanisms, there are kind of psychological reasons I can understand, and it gives you some comfort to put something to paper, or it may be more obvious to you. Maybe you are making good points, but you're not explaining the importance of each separate fact on paper. Maybe some of that analysis is staying in your mind. Whatever the case, and there are probably good reasons that people who are doing this, you still have to bring yourself back to the moment and ask why you're doing it. And the key is to unpack what you're thinking and set out explicitly what the legal importance is of each of these facts that you're talking about. So this is one extreme, people citing too many facts. The other extreme is people citing too much law. And there's a slightly different mentality that may go with citing too much law. I have seen people cite multiple cases in a single line. I think, honestly, even citing 2 is too many. Some of this impulse is this: hey, prof, I did the reading. It's something that we've discussed before, and it's still something that'll come up. It's an impulse that you have because it's what you were trained to do on your old exam. So there are perfectly good reasons that people who are doing this are doing this. Despite those good reasons, you need to make the adjustment to writing in a way that doesn't oversight the law, that's weaving fact and law together. So there is an element, even if this is not how you're putting it to yourself, even if there's some part of it saying, no, there's all this law that's relevant, and I need to show the professor that I'm doing that. Ask yourself why you're citing something. And it's another thing, as with citing too many facts, if you're piling up too much law in a sequence, you need to unpack it and find the facts that are causing you to cite that law, and to have a more detailed discussion about why you're citing each bit of law, or why any bit of the law is relevant to the facts that you're dealing with. This is less an extreme and something that everybody needs to do more. So a general problem is that there's not enough, and there are a million ways that this is referred to, I think, by other people, interweaving facts and law. But this is the hardest part, I think. And nevertheless, it's something that nearly everyone needs to do more of. It's difficult enough to figure out what the law is, as we've talked about before. But once you have some law, at least it's something concrete that you can cite. With facts, at least these are things that you're given in a hypo, and so that's something concrete. The glue, the mortar that creates the wall that allows you to, whatever analogy you want to use, that ties these two things together, that's provided by you. Why is a fact relevant to the law? Or how did you come to a conclusion as to why one party prevails on a given element and the other party doesn't, or why a party prevails on a claim overall? That's all reasoning that's provided by you. And I can't remember if this is Yertle the turtle. It's turtles all the way down. Ultimately, I don't know the depth of objective truth there is to a judgment. Even if there's a case that's precisely on point, there's at least one level of analysis you can at least think through that's a little bit deeper. By which I mean, sometimes, let's say you're given an easy slam dunk fact that reproduces exactly a case that you read in class and that you've briefed reasonably well. You can't just, the easy way to do it is just, this fact is just like this case. The problem is there almost isn't a case that's exactly like another case. This is one of the things that you learn, and that makes you different from a non-lawyer, is that facts don't speak for themselves, and the law doesn't speak for them. The law doesn't speak for itself. You still have to draw out the analogy. This is almost exactly on point, that you still have to say, because the professor wants to know what it is that causes you to come to that conclusion. And that's the easiest possible case in which, you can shift without using the clutch. I hear that there are speeds where you can do that. I don't know how to drive a stick. But that's my analogy. There's some places where you'd have to use very little glue, but you still have to use some glue to attach these two things. So imagine when there's an ambiguous case, how much harder this is. Well, you don't have to imagine. Those of you who are on, I know that you've all done practice exams. It's your own reasoning that's the glue that binds fact and law. Facts don't speak for themselves, even for res ipsa loquitur. I've spoken in the past about different ways to make your points, and hoping to develop more of those. But this is the thing, that because why does a fact apply to a law? Why does a fact fulfill an element? And a lot of that is developed from your own common sense or your understanding and the inferences that you can make about a given situation. This is when you write, even outside of the context of final exams, this is what's actually important. Not the bare facts, although there's a lot more to investigate when you're not just given the facts. Not the law, there's a bunch that you can research and the law can really help you. You still have to put these together. And paying attention to that, making sure that you're not just assuming that this fact fits this element. The professor knows, you might well be right. The professor knows that that's the case. The professor wants to know how you articulate the connection between the fact and the law, even if it's glaringly obvious. So really keep that in mind as you do your analysis, because this glue is what you create, and it is ultimately what the analysis is. Otherwise, it's just a pile of facts and a pile of law. Two other general exam mistakes I notice. Some of you will have noted, whether I use these words directly or not, that my sense that we're all on a journey, you're all getting better, I'm still getting better at this. But see, one thing that everyone could work on is being more nitpicky. I mean, I have a whole video on nitpicking the shit out of the facts. And I've noticed, and it's easier for me to point out in individual exams, but there are places where many of you are just glossing over facts. And I realize it's easy for me to say, you don't have infinite time and you're going to have to skip some things. And even an A exam is going to miss issues. But there are places where some of you addressed issues and you grappled with something where there was a nit to pick with the facts. You actually got the issue, but you didn't see the subtlety or ambiguity in it, or you didn't address it. It read like you were kind of rushing to apply facts to the law to get to a certain conclusion, but missed that fact was a bit of richness that your professor really wanted you to analyze. So it's not that every fact means something. For some professors, it will. Some professors like to put in red herrings. And even those are issues, at least pointing out that some fact is a red herring or looks like an issue but isn't really. But some facts are just background to establish other facts or to create a backdrop. So even if not, in reality, not every fact has legal significance, you should treat nearly every fact as if that's the case. Or you should at least err on the side of assuming that each fact is important. And if you kind of really, at least that makes sure that you've put your attention on that fact, that you haven't dismissed it. If you've spent a lot of time with a fact and you've decided that it's not important, then that's a judgment that you deliberately made and you moved on. But nitpickiness does beg the question of how you can know what you don't know, how you can notice the things that you don't notice. And I think one of the few mechanisms is to ask yourself, am I reading this as carefully as I should? Is there something here that I'm missing? Because remember what we know about professors. They got hired because they write original things. They try to find new theories that no one's thought of or debunk ones that everyone thinks is the conventional wisdom. They like novelty. The only way that you get novelty in the context of a law school exam is a subtle point or an ambiguous one that you successfully pick apart and put a lot of pen to paper on. The way to actually flesh this out and not miss these subtleties and not miss basically your opportunity at an A is to be sufficiently nitpicky. Now, backing up, all of this assumes a lot of basics are down. Of course, this is a very difficult exercise if you're still struggling with understanding the law or application, and that's why I've urged for a while, and many of you have followed through on doing lots of practice exams earlier. But once you get to a point where you're getting the basics down at a decent speed, you can stop and smell roses like these, involving the subtle and the ambiguous. Okay. Last thing is that some of you write too long. And there's a tension here because I want your analyses. There is some tension here, despite what I suggested a bit earlier, between being nitpicky and writing short. The name of the game here is really word economy. So the law is nothing like literature in terms of the beauty of its structure, but if you can do one thing, it's to think Hemingway. I don't know why I couldn't say that. Short, discrete sentences. Whatever you do, don't write anything like you think lawyers write. If you pat yourself on the back for sounding lawyerly, sounding anything like any TV show that you've watched, I hope that doesn't sound condescending, but people do write in a stilted way that they think sounds lawyerly. Short, sweet sentences and lots of analysis. Unearthing short, sweet sentences addressing all of your assumptions, showing all of your work, every bit of why a fact applies to the law. Lots of explaining has to be done, but it's in the form of short, sweet sentences using your shorter Anglo-Saxon, not Latinate words, shit instead of excrement. Almost all of you could use work with this. So let me rephrase two things. Writing what you actually write that is critical to analysis as short as you can. Again, this takes practice. And kind of looking over your work, having the time to look over your work a second time and revise it, and not saying things that, not elaborate setups. So let me back up. Excluding sentences that don't do work. A lot of you are writing sentences that want to introduce a topic because it's kind of polite to introduce people you haven't met, or it's why in the 5-paragraph classic essay format that people learned in high school, which is still relevant, you have to kind of introduce what you're talking about. You introduce if you need to introduce, but if you don't. That sounds, that's as circular as you can get. But ask yourself first if a sentence is actually doing work or if it's not important. Mini IRAC, again, helps with that because sometimes issue statements feel unnecessary and you can kind of trim them and just start with a conclusion if that's what's called for. Otherwise, with what you have, see if you can say what you're saying in fewer words.